the problem when you have.
I'm on.
We are ready to get started. Welcome everyone to the Burn Institute of Bioethics seminar series. I'm delighted to introduce Liable Fowler. She's a research assistant professor and research director in the Health Law and Policy Institute. Her work explores topics at the intersection of consumer technology and health, focusing primarily on smartphone applications and platforms. Prior to being at UH, she was the health policy program manager at Baylor College of Medicine's Center for Medical Ethics and Health Policy, with which many of us are familiar, where she maintains a designation in the health policy scholar.
All right, I think I get to take it away now.
Yeah.
Well, thank you. Good afternoon, everyone. And thank you so much for having me here today. And on top of that, for being here with such enthusiasm after the Thanksgiving holiday. I know that this is a busy time of year, so your attendance means that much more to me. And as you now know, my name is Liable Fowler. I'm a research assistant professor at the University of Houston Law Center, where I'm also research director in the Health Law and Policy Institute. And as you just learned in my introduction, my research lies at the intersection of health, law, and consumer technology, with focus on smartphone apps and social media platforms. Sort of stated broadly, I'm interested in the ways that people receive protections in a medical and scientific context as compared to the types of protections we see in a consumer context. And I'm particularly interested in this from the perspective of both the safety, efficacy, and accuracy perspective, as well as the privacy and security perspective, with an overarching goal of considering the consumer experience as holistically as I possibly can. And my recent legal scholarship has mostly focused on the smartphone applications prong of my research agenda. And for those of you sticking around for the postdoc and fellows seminar, we're actually going to talk about health apps there. So I think that's going to be a lot of fun. But while I've done a few empirical projects looking at health information on platforms like TikTok, this project is actually the first time I've gotten a chance to really dive into some of the legal issues. And we're hopefully going to present, me, my co-authors and I, at least one solution to the multiple problems that exist with respect to health and misinformation on social media. So my talk today is about social media influencer liability, and it stems from an in-progress project called Influencer Speech-Torts, which I'm co-authoring with Max Helveston at DePaul Law School and Max Helveston of DePaul Law School and Zoe Robinson of Australian National University. And in it, we're focusing on how medical and scientific misinformation can cause physical harm and the possibility of imposing tort liability on influencers vis-a-vis their injured followers when this occurs, even in the face of plausible First Amendment obstacles. And I think this is a really exciting topic to bring to this audience in particular, because it involves a real clash of fundamental interests, namely the rights to physical liberty of the follower and the liberty interests of the influencer to speak. In my opinion, at least, it's a perfect combination of the types of policy and legal issues that mean that reasonable minds can differ on what the right solutions are and whether this is even the correct or even the most efficient way to go about addressing aspects of this problem. And because I am sure our questions and discussions today will be really exciting, and because this project is still in progress, I am sure that all of these conversations will contribute to this and subsequent projects. So enough preamble, let's go ahead and talk about health misinformation on social media. Or not. Or extra not, huh? All right, now we can. I have great news for all my glasses wearers in the audience. You actually don't need to wear them. You can put essential oils around your eyes and take classes to rid yourself of the limiting beliefs that actually impair your sight. And I actually have some good news and bad news for the rest of us. The bad news is, and I'm sorry because you're eating, we all have parasites. But the good news is we can actually put cleaning solutions into our coffee and drink them every morning to help rid ourselves of those parasites. Now, of course, neither of these things is true. Please do not take this as medical advice. Don't put essential oils into your eyes and do not drink borax at all. However, the existence and persistence of this type of harmful health-related content on social media, and so many more examples that I could have put up there, are why we're here today. This big picture theme of health misinformation on social media has been a hot topic lately, and I'm sure many of you in the room are familiar. It seems like you can't log on to a platform without encountering something about health or wellness, and the growth and interest in this type of information is likely driven by many of the usual culprits. People, especially from marginalized populations, often report feeling ignored or gaslit or pressured by their physicians. In some spheres, trust in medicine is waning. Access to care, physician shortages, and high costs continue to be big problems. Any one of these variables could push people to turn to social media and other avenues to look for medical care. And of course, some of this content's popularity is likely driven by the fact that most of us are online and many of us are on social media. The literature also bears this out. Searching your online network is common for people looking for health advice, especially young people, and research has shown that people are becoming somewhat more reliant on people with health experiences that mirror their own and less reliant on their physicians. Now, some of the information that people find online will be harmless, and some of it may even be beneficial. But importantly, sometimes the health misinformation that you find will be harmful or even dangerous. And this has enormous implications, not only for individual health, but also for the medical and scientific establishments. And you don't have to just take my word for it. Robert Califf, head of the FDA, this guy up here, has, if not somewhat controversially, described health misinformation as the leading cause of meaningful life years lost and the most common cause of death in the United States. And the Surgeon General has also identified it as a moral and civil imperative requiring a whole of society effort to address. But the how of addressing it has proven somewhat elusive. So to get to at least one of hopefully many hows in this possible whole of society effort, I will walk you through what our current thinking is on the Influencer Speech-Torts project. First, I will explain what influencers are and how they can craft an identity as an online friend or peer, all while peddling health advice and products for profit. We'll also talk about the challenges of categorizing this information as commercial or creative, and how existing laws, though pretty good at some things, are limited in their capacity to provide remediation to followers for physical harms. Second, we'll turn to tort law. I'll briefly suggest why, even if tort law is not a silver bullet, it is a flexible and context-specific mechanism that individuals harmed by influencer misinformation may be able to deploy moving forward. I will spend a little time here focusing on duty of care. And because while we argue that influencers would likely meet even the narrowest jurisdictional standards for imposing a duty of care, imposing duties involves more than just the reflective application of doctrinal rules. It also requires courts to balance the competing interests of the tortfeasors and the victim. And by that, I would mean the influencer and the follower. Third and finally, we will focus on what we consider to be the influencer's chief interest that needs to be balanced. Here, that's freedom of speech. The First Amendment is often relied on as both a doctrinal and policy trump card to avoid liability. And the First Amendment is often wielded as a reason that there's nothing that we can do about health misinformation online. So here I will highlight the possible First Amendment obstacles, including what we think they are and why we think they are surmountable. And I will note that while what we're discussing here is relevant for tort liability, specifically the First Amendment and the constitutional sorting of influencer speech, but it is also important beyond that. It could potentially be important for things like possible regulatory or legislative interventions or other types of approaches to dealing with health misinformation online. And I know this audience comes from a lot of different backgrounds, so I will try to define as many terms as I possibly can, but if I happen to miss one, we'll catch those in the Q&A and I'll make sure we're all on the same page. So without further ado, let's talk about influencers and their unique combination of creative and commercial content. And to do that, let's just go ahead and briefly go back to our 2 TikTok video examples from the beginning. Influencers are people, as a descriptive matter, influencers are thought leaders who build and leverage their online social networks to influence people in that network to engage in certain behavior through advice or encouragement to purchase proprietary or third-party goods or services or to engage in content. And I want to be very clear here that I'm not just talking about suing anybody. We're not talking about your distant friends or relatives that you may see on Facebook saying that the COVID vaccine gives you 5G. We're actually specifically talking about influencers here. And there's no set definition of what an influencer is. However, many people try and draw lines around what it could be based on the number of followers that an influencer has. But even this is not quite so clear-cut. You don't actually have to have a ton of followers to be an influencer. They come in all different types of sizes, with some scholars dividing them into 5 groups like celebrity, mega, macro, micro and nano, with followers ranging from 1 million on the celebrity and macro side to fewer than 10,000 on the nano side. But no matter the following size, influencers exist for a commercial purpose, even if it's not immediately obvious. These individuals appear to authentically share their experiences, advice, and trusted products for the good of their followers. But in many instances, they're spreading medical and scientific misinformation for money, or at least the hope of more commercial opportunities down the line. What makes these individuals influential is the way they present themselves to their network as a friend or peer who is likable and authentic and therefore trustworthy and credible. But the twist, of course, is that this apparent authenticity and unfiltered nature of the influencer is not real. It's carefully curated to drive follower engagement and monetization, even if it doesn't look exactly like what we think about when we typically think about commercial speech. On the end that looks most like what we might expect, some influencers engage in direct commercialization on their platforms. And we can start by just thinking about discrete posts like these 2 TikTok videos depicted here, independent of their broader channels or accounts. Some influencers will share their own products and services, like this woman on the screen who specifically sells health coaching and essential oils. Others are going to enter into contracts with brands or other types of funders to advertise, sell, or endorse products in a seemingly authentic way by creating content related to a brand that is also paid for by the brand. And perhaps interestingly to you, because it was interesting to me when I found out, these types of third-party contracts don't always look like selling a product or even selling a service. Even simply expressing a viewpoint for a third party can represent a lucrative business opportunity. For example, in 2021, several European YouTubers expressed concern after a subsidiary of a digital marketing company contacted them on behalf of an anonymous client to spread vaccine disinformation. The influencers were never actually asked to sell products. They were only paid to share a specific set of decontextualized data and links to specific articles. And this mysterious opportunity would have allegedly paid 2,000 euros. And if you're wondering, this is a creator who many think may have taken this opportunity given the content of his videos, and he has since removed the video, but he does have a following over 1.7 million people on YouTube. But beyond these examples of direct commercialization, some influencers endorse a brand or product without expectation of direct payment, but perhaps instead in exchange for free stuff that they've received in PR. And by this, I mean a brand will sometimes sell influencers things absent a contract with the hope that they will perhaps show that product favorably on their accounts. Others, like the other example on this slide with borax, endorse products and ideas for no obvious financial motive. I personally doubt that Borax sent this woman free laundry detergent or that they have somehow entered a contract with her to sell this product or market it in this specific way. Instead, these people are likely making these videos either because they think this is actually great health advice, or they know that posting videos like this will drive engagement, especially if the content is controversial and therefore more likely to drive engagement and then go viral, and therefore getting in front of more eyes and getting more engagement and creating more economic opportunities down the line. But let's pause here briefly to talk about what I mean when I say engagement. And this last point about virality. Social media engagement is an umbrella term for actions and that reflect and measure how much your audience is engaging with your content. And social media engagement can include things like likes, comments, direct messages, but it's ultimately going to vary by the platform. And influencers can then leverage information about this type of engagement for commercial gain, because brands want to know that partnering with influencers is ultimately going to get their product or service in front of the most people possible. And when I say controversial content can drive engagement, what I mean is that a little shock value in this context can lead to a dollar value. People tend to engage more with content that triggers a strong emotional response, even if they're interacting with it negatively. And a platform's algorithm will then promote that content precisely because people are engaging with it at higher rates than other types of content. And interestingly, the more often somebody sees and encounters this misinformation, perhaps because it has repeatedly gone viral, the more likely they are to believe it, even without any evidence. So now that we've got a sense of what engagement on a singular post looks like, let's zoom out and talk more about accounts and channels. Some influencers create commercialized channels or accounts, but not necessarily discrete posts through various platform-specific and alternative monetization methods. For example, YouTube creators may be eligible for the YouTube Partner Program, which gives certain creators a percentage of revenue based on advertisements shown on their channel. Others can ask for support via things like Cash App or Patreon, or even sell their own merchandise. You can see some examples of this on the video description posted here on the slide. And what's interesting is that creators are likely doing all of these things, including this and some of the different approaches that I described earlier, either be contracts or selling their own services at different times. Now, like I was mentioning before, the value of influencer marketing is that the product or service is marketed directly and authentically by the influencer to the follower by somebody who is creating their own content. And this content is often creative in nature. In fact, influencers can even be considered artists. The Screen Actors Guild has even extended membership to influencers. And importantly, influencer marketing is not about the single post peddling a product. Instead, the success of this approach rests on influencing follower engagement, building trust and friendship. Thus, any reliance of an influencer's follower on advice is the product of an influencer's long game, which includes posts that are exclusively non-commercial and likely not misleading at all. And we can see this contrast on the slide when comparing an individual post promoting a psoriasis medication as opposed to the influencer's entire account, which shows her beautiful life and her clear skin. What you get as her follower is the belief that if you buy this, you can also have that. And you want Otezla specifically because you want the brand that is this person. And you may want these things and trust this recommendation because you believe you have a real relationship with this person. And there are good reasons a follower might feel that way. In all of these situations, the influencer is speaking to their network of followers. And from the follower's perspective, the influencer becomes a peer or a friend, sometimes even more. Relationships between influencers and followers can even become what's called parasocial, creating a one-sided sense of intimacy and connectedness on behalf of the influencer or on the follower to the influencer. And though this can happen with any type of celebrity or public figure, it is amplified by social media, which is technology that specifically allows you to engage with these people in the exact same ways that you might engage with your family or your very best friends. And in parasocial relationships, opposition to attempts at persuasion decrease, and the likelihood that a follower will comply with the influencer's message increases. So now that we know what influencers are and some of the sources of their influence, and sometimes how they can leverage that for commercial gain, let's talk a little bit about what can currently be done about false or misleading content on social media. And we can do this before getting to the potential promise of tort law, because I think that it's worthwhile to talk about the tools that we have in our toolkit so that we don't have to do something new if we don't have to. We wouldn't have to do something innovative and risky, like potentially sue influencers. And by way of disclaimer, I will be taking a very high-level look at some of these topics, but if any of these interest you, we can talk about them more in depth in the Q&A, but to do so at more in depth now would probably require more time than we have. So on the platform side, one of the most popular approaches is content moderation, which is a process of monitoring and removing user-generated content if it violates certain standards and guidelines. All platforms can do this, and if you believe the terms and conditions of the Apple App Store and the Google Play Store, it's actually a requirement in order to post your platform and make it available for download on whatever, a smartphone device or another device. And while some platforms are actively pushing against content moderation, and I'm specifically thinking of Twitter, X Corp, others are doubling down on their commitment to remove videos that have harmful or misleading content or otherwise discourage talking to your medical professional, specifically YouTube. But content moderation is not a perfect solution, and it's not without controversy. From a practical perspective, all platforms struggle to keep up with the sheer quantity of user-generated information on their platforms. And though this process can be automated, it is still often a manual process. And there's understandably high turnover in positions that require the systematic review of upsetting or otherwise shocking content. Another is that groups spreading misinformation are sophisticated, and they've often developed tactics to avoid content moderation that capitalize on flaws in social media architecture. But there's also legal and legislative challenges. Texas and Florida have both tried to legislatively limit platforms' ability to engage in content moderation, and this has resulted in a circuit split, and this case is going to make its way to the Supreme Court. Luckily, we do have more entities in the fight. Beyond platforms, the big players in the space are the FDA, FTC, and state attorneys general. The FTC and FDA have overlapping interests and authority in addressing labeling, advertising, and endorsing, including influencer misinformation that can cause injury to consumers, though the FDA primarily focuses on things with an intended use as a drug. And when it comes to influencers, both agencies are most commonly concerned with adequate disclosures. The FDA with the imbalanced information about the risks and benefits, and the FTC with the veracity of health claims and advertising, and adequate disclosures of sponsored content. And typically, the FTC and FDA send letters, be they untitled letters or warning letters, to influencers when they believe that they've run afoul of the appropriate requirements. And those warning letters tell influencers to fix the deficiencies in their post and carry the potential of a fine or a civil penalty. And we can see two examples here. In cases where the FDA and FTC pursue influencers, it's generally big names. Here, the FTC sent warning letters to people with millions of followers like Jordan Sparks and Cardi B for not disclosing their financial relationships with Teamy, the company that sells their products as a cure-all for a variety of physical ailments in addition to the weight loss and beauty products you see here depicted on the screen. And in this example, the FDA sent a warning letter to Kim Kardashian for not adequately discussing the risks of diclegis, which is a morning sickness medication. Now, it is worth noting that this is a little bit of an oversimplification. The FDA and FTC do have additional powers, and we can talk about some of those in the Q&A. But this is generally what it most commonly looks like when these agencies intervene with influencers. It looks generally like letters. But beyond sending letters to influencers, it can also look like trying to tweet corrective information or working with social media companies on content moderation. Or can it? Because of course, if the Fifth Circuit is to be believed, there may be significant limits on what agencies like the FDA can do about misinformation on social media. The FDA might not even be able to tweet, "You are not a horse," in response to ivermectin misinformation. This case is called Apter versus HHS. Apter is a case brought by 3 doctors, and what you see here is an excerpt from the Fifth Circuit's decision on an appeal of a motion to dismiss that the district court had granted and the Fifth Circuit reversed and remanded. The doctors are arguing here that the FDA's horse message and similar public statements violate the FDA's Enabling Act and the Administrative Procedures Act. Stated broadly, the core of the Apter case is the assertion that the FDA lacks express authority to discourage off-label use. Now, this decision left a lot of people scratching their heads for a lot of reasons, but if you want to take the doctor's core argument at its most basic, it's that the FDA cannot act without express statutory authority. The FDA does not have express statutory authority to recommend against off-label use for drugs approved for human use. The post recommended against ivermectin, which is a drug approved for human use, and therefore the posts are beyond the FDA's authority. It remains to be seen what the district court will do with this case now that it has it back. The other case is called Murphy versus Missouri, and it involves similar actors, namely agencies and social media. This case concerns 2 lower court decisions which found there to be a coordinated campaign by high-level federal officials to suppress the expression of disfavored views on public issues. Now, setting aside the Hunter Biden laptop and election fraud prongs of the facts of this case also involved COVID-19 misinformation. Missouri and Louisiana and various private parties filed suit, alleging that the federal government was coercing, threatening, or pressuring social media companies to censor protected free speech. This is sometimes called jawboning. In other words, government officials were suppressing protected free speech by controlling or otherwise forcing social media companies to make content moderation decisions to censor that content. And last month, the Supreme Court lifted the injunction that had been set by the lower courts, which again allowed federal governments to communicate with social media platforms, and they intend to hear this case during the current term. Now, while the details of these cases are interesting, you don't actually need to know too much about the legal specifics. What you do need to know, though, is that agency attempts to address health misinformation online are imperfect, and they are not without controversy. They are, in fact, the subject of active litigation right now. Now, finally, state consumer protection laws provide an example on the state side. Here, Brittany Dawn Davis settled with the Texas Attorney General for allegedly violating the Texas Deceptive Trade Practices Act earlier this year for misrepresenting her personalized wellness plans and holding herself out as having expertise in eating disorders that she never had. So DTPA cases are thus a potential avenue for injured consumers to recover. And while the Davis case involves a class of plaintiffs, there are also some avenues for individuals harmed by speech to be able to recover via cases like this. In fact, individual consumers can pursue cases under the Texas DTPA. And though this specific case did not specifically involve physical harm, it instead involved economic harms, specifically that people bought products based on misrepresentations that they wouldn't have otherwise bought. But while it doesn't bar claims for damages from personal injury, it does ultimately limit them to economic damages. Non-economic damages, by which I mean things like pain and suffering, which are very common in personal injury cases, are beyond the scope of the Texas statute. But of course, all states have something similar to the Texas DTPA with respect to consumer protection laws, but they vary significantly. While some states do not permit individuals to bring suit, and others are limited to certain types of commercial activities and exchanges. And that means that it is a complicated potential solution for individuals harmed by influencer speech, and thus is not a perfect fit. So all of that is pretty good, but if health information on social media is still growing, and those actually injured by this type of harmful content don't have many avenues to recover. And that's where we think tort liability could come in. We argue that what's missing from the discussion of legal mechanisms for controlling or remediating misinformation is tort liability, specifically negligence or negligent misrepresentation claims by individuals against influencers. In our research, we were surprised to find vanishingly few cases involving tort claims of any kind by followers against influencers, and even fewer alleging any type of physical harm. And this surprised us because misinformation is at the heart of negligence and negligent misrepresentation in the real world. And at least as far as we can tell in our work, there are likely many reasons for this lack of tort cases in what feels like a really obvious space for there to be some. And we found it puzzling, so we offer a few ideas for why it might be in the paper that we're working on. One is that it could be that torts in the real world tend to lag behind, torts on the internet tend to lag behind torts in the real world. And the other, it might be more of a practical reason. Not everybody is going to strike it rich on social media. So it could be a simple fact of a decision that influencers may be judgment proof and therefore aren't worth taking on these types of risks to sue these types of defendants. And this is, by way of definition, likely because plaintiffs' attorneys who would take these cases are paid on a contingency fee basis, which means they get paid as a percentage of any type of settlement or claims or money earned in litigation, which means they take on the financial risks of these cases early, including expensive things like getting an expert. And so they may deem that something novel or not guaranteed to win is not worth bringing these types of suits. But even beyond these possibilities, we offer that it could be something even bigger. Specifically, it could be that the existence of a duty of care is not sufficient to impose liability if other important public policy considerations counsel limit or eliminating that duty altogether. And that last bit about public policy considerations is a bit of dramatic foreshadowing for what I'm going to talk about for the rest of the talk. But before we get there, let's talk a little bit more about tort law. A tort is a civil wrong, and tort law is concerned with remedying the harms caused by a person, sometimes called the tortfeasor's, wrongful or injurious conduct. And we suggest in the paper that common law negligence or negligent misrepresentation could provide a vehicle for individuals harmed by influencer and misinformation. And we engage with the elements of these causes of action in our paper, but for purposes of this audience, I want to take a bigger picture approach and talk about why we think tort liability could be a good fit, but why duty is a potential roadblock. As a general matter, to hold an influencer liable for negligence, a follower needs to demonstrate that the claim's 4 fundamental elements are satisfied. That is to say, they would need to show that the influencer owed them a duty of care, that they breached that duty, and that that breach caused them to suffer damages. With most common law legal standards, the doctrinal rule for determining whether a duty exists is jurisdiction dependent. Now, we don't argue in the paper that negligence claims will ensure liability, only that they could be viable if difficult to prove. But even acknowledging this, we propose that because the common law has an inherent flexibility and cultural attunement, it's better at responding to advancements in technology and communication that can outpace legislative and regulatory regimes. This means that tort liability could provide just one of many solutions to otherwise hard to solve problems like influencer misinformation on social media, and wouldn't necessarily do so at the expense of other possible avenues. More specifically, negligence claims at their heart embody societal judgments about permissible and impermissible conduct. And we see these judgments baked into each element of the cause of action. At its core, the duty of care element of negligence requires a judgment about the nature of the relationship between a defendant and plaintiff. So, are followers of social media influencers a foreseeable class of plaintiffs? Or is there or should there be a special relationship engendered by an influencer choosing to post misinformation that their followers will inevitably see? Similarly, the multi-factor nature of the breach of duty analysis in most jurisdictions directs a flexible and culturally relative response by the fact finder. Questions about whether the influencer misinformation has social value or whether it was foreseeable that the kinds of harm suffered would result from the influencer's posts are inherently context specific. Now, this is not to say that influencer negligence avoids the tricky questions that are common across all types of tort liability. Breach of influencer duty in influencer speech torts cases raises complex issues of proof relating to falsity And the difficulty of proving falsity depends on the nature of an influencer's claims, from the easiest scenario where the influencer makes a claim that is uniformly recognized as false, to more difficult claims where perhaps there's no scientific consensus, or something that is technically true but lacks additional information that prevents it from being misleading, or perhaps something that hasn't been studied yet, either because it's not something we've got to, or perhaps there's no ethical way to design a study to test the hypothesis. Likewise, causation raises difficult fact-based questions about the connection between the influencer's misinformation and the follower's harm. But these challenges are not unique to influencers or torts that are happening on the internet. They face plaintiffs in all negligence suits. So to us, tort law makes intuitive sense. After all, a tort on the internet bears significant resemblance to a tort that happens in the real world, but it is the site of the influencer's misinformation that calls into question whether a duty of care should be imposed, not simply whether it can be imposed. While influencers would likely meet even the narrowest jurisdictional standards for imposing a duty of care, and by that I mean they pose a foreseeable risk to a foreseeable plaintiff, imposing duties involves more than the reflexive application of doctrinal rules. It also requires that courts balance the competing interest of the tortfeasor and the victim, in this case, the influencer and the follower. And this is where we get to those public policy considerations I keep alluding to, specifically freedom of speech. Here, the subtle differences between an in-person tort and a tort on social media become significant. Influencers speak, and social media, which is technology specifically designed for people to speak to each other, highlights the centrality of speech in these cases. Indeed, the First Amendment is often relied on as a doctrinal and policy trump card to avoid liability. And in other contexts, courts have been reluctant to impose a duty that overrides a tortfeasor's speech interests. Instead, courts have concluded that the speech interests either justify a categorical no-duty rule on the grounds of public policy, or they act as a constitutional defense to a negligence claim, even when duty has been imposed. And you might be wondering why we care about the First Amendment here. And that would be a valid question, because normally when we're thinking about the First Amendment, we're thinking about things that the government has done to restrict our speech. However, the First Amendment comes into play because the Supreme Court has consistently held that the state's provision of a forum and cause of action for private law claims comprise state action for First Amendment purposes. However, the Supreme Court has not addressed the intersection of negligence in the First Amendment. This means that the threshold question is the applicability of the First Amendment. So in other words, is influencer speech covered or uncovered speech? In our paper, we suggest two avenues by which negligent misinformation might be uncovered speech and subject to rational basis review, rather than the heightened scrutiny afforded to covered speech. But before I jump into these two avenues, I want to give you a few definitions and a little bit of context, because I know that not all of us have a legal background. When I talk about covered versus uncovered speech, these categorizations are relevant to the standard of review the court will apply to judge whether something is constitutional. And there are at least nominally 3 levels of scrutiny. The lowest is called rational basis review, and it requires that whatever is happening be rationally related to a legitimate government interest. This type of review has historically required very little for something to be deemed constitutional. And under the rational basis test, the person challenging the law must prove that the government has no legitimate interest in the law or policy, and there is no reasonable rational link between that interest and the challenged law. Courts using this test are highly deferential and will often deem a law to have a rational basis as long as it has any conceivable rational basis. The middle level of review is called intermediate scrutiny. And in order for a law to pass intermediate scrutiny, it must serve an important government objective and be substantially related to achieving that objective. And the highest level of scrutiny is called strict scrutiny. It requires proof that there is a compelling state interest behind the challenge policy and that the law or regulation is narrowly tailored to achieve its results. Legal scholars will often say that strict scrutiny is strict in theory, but fatal in fact, because the popular perception is that most laws subject to strict scrutiny are deemed unconstitutional. And while this is a lot of information, what I want you to take away from this is that we want the speech in question, the influencer misinformation, to be uncovered, because then it would be subject to rational basis review and therefore more likely to survive any legal challenges. So how do we get there? How do we get to uncovered speech and rational basis review? Like I mentioned a moment ago, the court has not addressed the intersection of negligence in the First Amendment, but it has provided some helpful guidance for figuring out whether speech is covered or uncovered. The Supreme Court has indicated that the First Amendment presumptively covers all speech, unless it falls within a narrow and well-defined and narrowly limited category excluded from the First Amendment, Or the litigant presents persuasive evidence that a novel restriction on content is part of a long, if heretofore unrecognized, tradition of prescription. The first avenue is misleading commercial speech, and this is where we take an attempt to fit into either one of those possible avenues. So if speech is both commercial and it is false or misleading, rational basis review will apply. But we suggest that the application of the commercial speech doctrine is actually tricky in the case of influencers due to the hybrid nature of their speech. And this is where I'm going to remind you a little bit about what I told you in the first part of my presentation. Remember that the value of influencer marketing is that the brand or product that is being advertised is done so directly and authentically by an influencer who is creating their own content. And this content is also creative in nature. Remember, they can even be considered creators or artists that SAG has even extended membership. So the issue becomes whether it is possible to sever the commercial and the creative content, because the court has said in other cases that commercial and core speech that is inextricably intertwined is subject to heightened scrutiny or heightened protections. So of course, there will be some instances where a single post where you can sever this type of commercial and creative content, and this intra-post hybridity can be resolved. But it is the inter-post speech hybridity rather than the intra-post speech hybridity that raises the biggest hurdle in getting to misleading commercial speech. Here, it's also helpful to recall some of what we talked about when we talked about influencers earlier. Remember that influencer marketing is not about a single post peddling a product. Its success rests on priming a follower, gaining their trust and their friendship in order to influence the follower to engage. It is ultimately a long game, which includes posts that are protected, covered speech, namely posts that are exclusively non-commercial in nature and likely not misleading in and of themselves. And we suggest in the paper that it's unlikely that the commercial speech doctrine is sufficiently elastic to extend to capture this type of inter-post hybridity. So we may have to set aside this specific commercial speech route in some instances and look elsewhere. So for this reason, we propose a second and we think more plausible avenue, which proposes that negligent misinformation is a previously unrecognized category of uncovered speech that has a long history of prescription via private law actions. And to justify this claim, we look to the context of other torts, because while the court has not specifically considered a claim that negligent misinformation is uncovered speech, it has considered the coverage question in the context of defamation and intentional infliction of emotional distress, both of which have a similar history of prescription via private law actions. And in answering the question of First Amendment coverage in the context of these other torts, we can see that the court's inclusion or exclusion of categories of uncovered speech is ultimately driven by the nature of the harm the plaintiff seeks to redress through their tort claim. This harm-centered approach seems to serve a specific purpose. The court's central concern in speech torts cases is that private law might be deployed and misused as a vehicle for suppressing speech. And the key indicator of whether a tort is being used as an end run around the First Amendment is the nature of the harm experienced by the plaintiff. Harm ultimately becomes a proxy variable used to determine the degree of danger that the tort presents to First Amendment speech. So tort actions where liability is grounded on intangible harms, specifically things like emotional harm, are overtly suspicious. The court has emphasized that the fact that anybody who feels hurt by speech could then bring a private law claim, say for something like intentional infliction of emotional distress, means that speech would be under constant threat because it is unpalatable to one person or another. The result would be a chilling of speech. And so for this reason, the court has thus far held that claims based on intangible harms like emotional harms are universally covered by the First Amendment, and strict scrutiny will apply. On the other hand, tort actions based on tangible harms pose less of a direct risk to speech. And this is because the tangibility of a harm is a signal that the cause of action is being brought to actually remediate harm rather than to suppress the speech in question. So the court has held that torts causing reputational harm are uncovered, although modifying the common law cause of action for defamation. And speech torts causing economic harm are uncovered, and rational basis review will apply. So while the Supreme Court has not grappled with First Amendment coverage of negligent misinformation, some lower courts have, though not on social media. And when they have recognized this distinction between tangible and intangible harms. And these lower courts have held that negligence claims resulting in physical harms are not covered by the First Amendment because the risk of the cause of action being deployed to chill speech is low, given that presence of physical harm. However, other lower courts have held that negligence actions where physical harm was present are covered by the First Amendment. What distinguishes these cases from things involving social media influencers, in our opinion, is the relationships and contexts. So where allegedly negligent speech is directed at the wider public, the speech harm connection has been held insufficient to overcome the First Amendment. These cases are usually either broadcaster cases where a third party or the plaintiff sees something on television and is inspired to mimic it, or publishers where misinformation is disseminated to through a generally available publication. Underlying these decisions that the First Amendment covers these types of negligent speech torts is the perception that when speech is directed to the general public, a claim that physical harm resulted from that generally available speech can be commandeered to suppress speech that society finds offensive or otherwise disagreeable. In other words, these cases look more like cases of emotional harm than the standard negligence cases with physical harm. So our claim is that the court's speech torts jurisprudence and the history of negligent speech torts in the lower courts suggests that influence or negligent misinformation claims are at least plausibly uncovered speech. The nature of the influencer relationship and the directed and private nature of influencer speech, as well as the presence of physical harm, present strong indicators that the tort action is remedial and not a proxy for commandeering speech. But whether negligence-based speech torts are covered by the First Amendment is just one aspect of the constitutional inquiry. And it turns out that harm also plays a central role in the means-ends analysis. Because regardless of the standard review applied, which are the three different standards that we talked about just a moment ago, the state's provision of a forum and remedy for litigation of private interest based in tort must be sufficiently tailored to the state's interest in prevention or remediation of harm through the tort claimant issue. And in the context of speech torts, whether the means-ends fit is sufficient will depend on the nature of the harm. So in looking at other precedent, the court has recognized that the state's provision of a forum and remedy to pursue a defamation cause of action is sufficiently tailored to the state's interest in remediating reputational harm. And further down the harm spectrum, the court has held that the state has a greater interest in protecting proprietary interests than reputation. And so the state's provision of a forum and cause of action for remediating economic harms is a sufficient state interest. And we argue that if deterrence to harm to reputation and property is sufficient, it follows that deterrence to physical harm would be sufficient. The court itself has suggested this is the case, specifying that the protection of physical liberty is an important interest. In other words, the greater includes the lesser. So to wrap it up, because we're coming up on time, we think that there's a valid argument to be made that at least some instances of influence or health misinformation online is uncovered speech, which not only opens the door to tort liability, but also potentially other interventions that may help slow the spread of this type of dangerous content, be they regulatory or legislative. And with that, thank you so much for your time and attention. I look forward to talking about it with you.
That was great. Thank you so much. That was a huge amount of information that I don't normally spend a lot of time thinking about. So I'm going to be processing for a while, but very clearly delivered. I have my own questions, but we already have. So I'll hand it over to.
Hi. Fabulously interesting. And I have a two-part question. First of all, this was very reminiscent of some of the early genetics that came on the market with this unsecure regulatory environment with claims that there was a propensity for teenage romance gene tests on the market and some of these really. So it's reminiscent of that as sort of the interstitial space where there's these things. But in terms of the tort, right, I was thinking of where do you go with a little hanging fruit like so there was the companies that are doing defame by saying all their brands are up there saying these costs, so who's the I'm not a lawyer, like the literature who had a plan. And the other one that already they all are. But the one people the vitamin K and not giving the infants vitamin K shots. In terms of thinking about what's in your test trial validity, the person being harmed is 8. His mother is listening to this fresh crack. So is that more of a priority of those? Like where do you start to test this in terms of best use test case to go forward?
Yeah, I think I don't need that. I have my own microphone. I don't need that microphone. So actually, that's a really great question, and it brings up a lot of line drawing that comes up when talking about this type of case. Like, what constitutes the right kind of harm, and who is the right kind of plaintiff? And I think you're right that sometimes cases are a little bit more clear cut than others, especially in cases involving a company that is directly selling a specific type of product, because usually they're advertising it in some way, and there's a very clear path. However, what we're more interested in is these influencers that are promoting this type of harmful conduct. And so I think in my mind, the ideal case is going to be a clear example of physical harm, because at least when we're conceptualizing harm can look a lot of different ways, right? It could be somebody who decided not to seek treatment because they thought they could get something better by pursuing one of these avenues. It could be somebody who stopped treatment against medical advice. It could be somebody who delayed seeking treatment and therefore it got worse. But I think the clearer cases are going to be these people who perhaps an influencer told them they could detox using turpentine and suffered significant injuries. So I think that's going to be more of your ideal plaintiff, because I also heard people bring up all types of harms, like the stress can also have physiological, all of that is important and good. And I think things that we can explore later, but at least in my mind, the ideal plaintiff is going to be somebody with some type of grave injury or death. And I think the other part of your question, and I would like to see it be against an influencer. And this brings up another question that people often raise is, okay, so a handful of people sue, how does this actually stop influencers from spreading misinformation? Valid question. I've gotten it several times. And I think there are a few avenues on that front. One is that influencers, especially those who make more significant amounts of money when it comes to producing this type of content, are starting to develop, or there's an insurance industry developing around influencers. And so if insurance companies can exclude certain types of content from their coverage, that could be one way of moving the needle. And the other is, and this came up in the Murthy versus Missouri cases, this idea of the disinformation dozen, that most of the vaccine misinformation and disinformation you found online could ultimately be traced back to, I think it was 12 specific individuals. So if you can find the people who are producing the majority of this information and have that person be your test defendant, that would be my ideal world. But it's finding these people and being able to bring these cases that will be more of the challenge.
I cannot believe a lot of what you're saying.
Moderate.
Hi, I'm Travis Reaver, super interesting. I'm a little bit like Deborah. So on one hand, I mean, I think that you and your co-authors are starting from a position of it would be good. It would be morally good to have a legal tool to rein in misinformation, right? So like this is an aim and on board. Right, social media is a cesspool, all sorts of terrible things. The one thing I did wonder about continually through your talk, though, is about unintended consequences of like providing a legal platform. Mm-hmm. And so I just wanted to spin out this thought to hear somebody's actual legal training comment on it. There are all these different levels of influencers, bottom which nano or whatever can be sub 10,000, right? So this would include a lot of academics, a lot of doctors, a lot of people who are like trying to actually contribute to this space. And I also am sort of acutely aware of when there's a legal platform that can be used as a bludgeon by those with money, mm-hmm. right? So like, I don't ever want to be sued, even if I know I'm right, because I'm a little nobody who can't afford to defend myself, right? And so I wonder if there's a sort of worry that if you provide a legal platform for this, it becomes chilling to not just Kim Kardashian, who maybe needs to chill, right? But for everybody who's like out there trying to provide good information, who can then be beaten by anybody with enough money to just throw lawyers and want to disagree with that.
That is a fantastic question. And I've never met you before, but I do want to say I loved your book. It was fantastic. So fangirl moment there for a moment. And I think that you're right that I start with a prior that it would be nice to have some type of legal tool. But one of the reasons we wanted to focus on something like tort liability, as opposed to something like that would be more of a blunt instrument like legislation or regulation, is because my other prior is that I actually think speech is good. And for the most part, social media is not the worst. Social media actually allows a lot of people to connect, and even the process of being an influencer is not inherently bad. I think that it's great to be able to share products, and I myself like to follow a lot of influencers on social media. I find the content engaging and entertaining. So I do think there's value there, even if there are corners of that part of the internet that are very low value in terms of speech. So I think your concern about chilling speech is really important. And it was something that was absolutely in the forefront of our minds as we were thinking about what could potentially be the right approach. And so my initial reaction to this question is why tort liability is such a good solution in these instances is because it necessitates, because remember when we think back to duty breach, causation, damages, we need a damage. So if the information you've put out there has not hurt anybody, you're not going to be sued. However, I'm going to extend your comment to a different criticism I've heard, because I actually think it's part of the same train of thought. And I actually think it's quite a good critique. This idea that it could potentially be weaponized by different actors. And there's a paper by Dorit Reese and, oh goodness, I'm going to forget his first name, but his last name is Diamond. And they wrote about the measles outbreak in Minnesota. And they were talking about the possibility that this type of action could be weaponized by people perhaps in the anti-vaccine group. That you got a vaccine, you have had a vaccine injury, and then could you then be suing people who were promoting vaccines? And I think that that's a valid concern. I think that that tends to be somewhat niche to vaccines, but I've been wrong on the internet before. And I think that there are different avenues you could approach that, especially like whether or not things like the vaccine injury prevention compensation plan could potentially preempt those types of cases. But I think it's a valid concern that it has the potential for some type of chilling effect. That's not what we want, but I actually think when you think within the realm of possibilities, this is potentially the most exact instrument we could come up with that is allowed for by the law. Because if you start passing regulations or different types of legislation, those tend to be much broader and I think have a greater capacity to have a chilling effect. But thank you for your question. It's a very good one.
It's really interesting. I guess, thinking about the beginning part of where you're finding influence, but I guess it's start thinking like, this doesn't seem new or unique, like the sort of nothing under the sun, that kind of thought. And so my question was, the types of speech that you're identifying often can be seen in some of the shadier things that religious leaders say and do, especially when it comes to drawing things. So like the cancer cases where you know, like, I don't know, maybe some of this is probably not that bad for you, but it means that you are not receiving cancer treatment. That's obviously the harm. And so I guess I'm curious about that connection. First, on the one hand, whether this same kind of argument can be used to regulate the speech of religious leaders who are doing the exact same thing. And second, if not, could influencers use that kind of precedent to protect their own speech in this case?
That's a fantastic question. And I think that you're right to point out that things like political and religious beliefs can overlap significantly with certain types of health misinformation that we're seeing on the internet. And I definitely think there's a possibility for that to occur. And that's one of the reasons that right now we're focusing on influencers and not just random people on the internet who are promoting different types of ideas or opinions, because the law protects your opinions, even if they're awful. And it should do that because we believe as a society that you being able to express those opinions is intrinsic in our ability to have a functioning democracy. So I think you're right that there are certain types of people that this would never even touch because they're not influencers. That's why we're focusing on those quite narrowly. But a case that you might find interesting that your comment or your question made me think of is actually the Genesis 2 case in Florida. I don't know if anybody here is familiar with this one. The Genesis 2 church was a fake church in Florida that was selling a product called Miracle Mineral Solution. And I actually may have some pictures of it on the slide up here. Miracle Mineral Solution is industrial bleach, and they were selling it to people to drink, and people were hospitalized and some of them even died. And this is one of those interesting cases where I was like, hey guys, I'm actually going to give you a really high level about what the FDA can do, because the FDA can actually do other things. Now, the FDA does not have independent litigating authority, but they can sort of rally the troops of the DOJ to sue when people do particularly egregious things. And in this case, the Genesis 2 church they made over $1 million in selling industrial bleach for people to drink, saying it cured things like autism and AIDS and HIV and cancer. And they ultimately they're in jail now. There was a sentencing in October, and I think the case was for the intent to defraud the United States by distributing a misbranded drug. And so this was a huge case. And this was a group that actually tried to identify as a church as a way to get around some of those more tricky issues in the law that you're speaking about directly. But what was helpful was they would say they weren't a church on their website, and they would take donations, but the donations were always set payments that people eventually had to pay to receive their Miracle Mineral Solution. So your concern is spot on. People could do that. But our hope is by focusing on influencers, it will continue to keep it focused pretty narrowly on people who are engaging in more traditionally commercial activities, as opposed to those who are doing more honest opinions, even if they are harmful opinions, and people who are protected by things like their religious and their political beliefs. But that's a fantastic question.
ask a question?
Yeah.
So say, Stephanie, you can always ask me questions.
So really what I wanted to earlier, Stephanie is working on the same project, right, with Nancy Cass as well, so we're deeply interested in this from the standpoint of the commissioners.
I'd love to share my paper with you when it's finished.
Right, so one of the things that I would love to hear you talk more about, two things actually, one is how the claims that the alleged endorsement is false. Right, so the falsity, the epistemic question, right? And the other is intention. If I think about the four elements, I'm not a lawyer. The only time I study tort law at all is trying to understand a little bit of medical malpractice, right? So I was thinking about this in the context of duties and breaching duties is very clear. A physician has a duty, a nurse has a duty, right? You breach it or not. If you could talk about two things, how does an influencer have a duty, right? To what extent is that duty involve being able to vouchsafe that you believe that this is accurate information? So there's an intention to mislead or intention to impart what is accurate, right? And then how do you show that their view is not accurate, that it is not potentially, possibly correct in some way?
Yeah, absolutely. And those three questions are excellent. They're actually central to not only this project, but what we're hoping will be a spin-off paper specifically focused on the difficulty of suing influencers. And this one we've chosen to focus somewhat narrowly on duty of care, just because there's a lot to bite off when it comes to negligence. But in other ones, we'll talk more, I hope, more extensively on things like proving falsity. But to your point, I'm going to start with the last one, because I think it's probably the most straightforward, which is how do you show, well, the middle one, because how do you show intent? One of the benefits of negligence is that you don't actually have to show intent to harm anyone. And so that's a reason that something like negligence is preferable to something like fraud, which often has a higher pleading standard. The other question that you had is about falsity. And I'm saving duty for last because I think there's a lot more to say on duty, at least based on this specific project. But falsity is a really interesting and difficult claim because, like I tried to point out in my talk, is that falsity can be a lot of different things. It's easy when somebody is telling you to drink industrial bleach because that's pretty uniformly recognized as a harmful thing to do. But it gets progressively harder as we move down this spectrum that I tried to describe, that, you know, maybe it's something we don't have full information on. Maybe we haven't studied it. Maybe it's something that is partially true. You know, maybe it was something that was proven in animal studies or shown in sort of a different capacity. And what's interesting about that is that happens all the time in negligence cases and tort cases in the real world, things that don't involve things like social media at all. It almost becomes a dueling experts situation. And so somebody who is defending the influencer would bring an expert that says, obviously, this is true based on X, Y, and Z data. You could bring a counter expert to come in and say things like, obviously, this is not true based on other things. And then it is ultimately a decision for the fact finder about who has the most compelling interest. I don't think the courts have to be the arbiter of what is true in the universe. And to kind of bring it back to Travis's question, it's also one of the benefits of tort law is you don't have to have the government deciding what is true. You can actually have fact finders based on the very specific nuances of that case, be weighing the different evidence about what could be true based on the different experts that they've brought in the facts of the case. So falsity is difficult. That's a really important point, but I don't think it's insurmountable in a way that it's difficult to prove falsity in a lot of different types of tort claims. The thing that we focus on most in this paper is the idea of duty. And I want to make sure that we're not running over time, but I assume y'all cut me off if we've gone over, and you can certainly leave if you need to go somewhere. But one of the reasons we focus on duty is because people, when we're talking about health misinformation online, almost reflexively, especially when we're talking about the First Amendment, will reflexively put influencers in the same bucket as broadcasters and publishers. And I'll try to draw analogies there because there's a lot of case law that says that the types of speech that those groups are doing is covered speech, and therefore, like, you can't really sue them. It's hard to sue a broadcaster. It's hard to sue a publisher. It's not impossible. But one of the ways that we think that they're very distinct is the relationships and context. So they're not like publishers because they're controlling the type of information they put out there. They make choices about the type of information they post. They create it themselves. They post it not only in a specific way, but at specific times of day, because that will drive the most engagement. I've even seen plenty of influencers take content down and post it again at a different time because they think they'll get more viewers looking at it. So there's a lot more control. So that's the first element where we think this is distinct from like a publisher or a broadcaster. And the other is the relationship that influencers have with their followers. So as opposed to being just a public figure, you have somebody that you can engage with on social media. And all of this could be an issue of fact for a court to decide. Did you have enough of a relationship with this person? Did you casually come across this information when it was going through your For You page, or did it show up because the algorithm gave it to you? That would be a weaker case than somebody who habitually followed this influencer, had posted several times as comments, or even sent them direct messages. So I think there are ways within a tort context to be able to prove that influencers have a greater relationship and greater duty, as opposed to encountering the same information sort of organically in the wild because you were scrolling through a feed that had different types of content. So I think that I don't think that proving duty is going to be the most straightforward thing that anybody has ever done. And I certainly think there will be cases where it might be easier for courts to say, okay, no duty in this specific instance. But in others in which there's perhaps this parasocial relationship or perhaps these more robust connections, it might be a much clearer case to make. So those are great questions, and they're central to the whole thing.
Well, thank you so very much for the incredibly engaging talk.